Vista Developments.
Now, before we begin, it might be helpful if we were to deal with the question of what issues can actually be argued here. Clearly, you've set out in your written case your arguments why you should be allowed to argue the issues of whether the clause in question is a penalty and whether alternatively it's a forfeiture clause from which you should be entitled to relief. And we have the respondents' arguments as to why we should refuse leave for these points to be introduced at this stage. The board have discussed this before coming on the bench this morning in the light of the arguments that you've presented. And we've come to the view that we should not grant leave for either the penalty point or the forfeiture point to be argued. Essentially, on the penalty point, we realise that this was argued at first instance.
Yes, ma'am.
But the board would have wished to have the views of the Court of Appeal. The Cavendish case was obviously a very important decision. It's proved to be quite controversial. Not every other common law jurisdiction has decided to follow it. And we would have wanted to have known what the views of the Court of Appeal were. So far as forfeiture is concerned, that's rather more straightforward because it wasn't raised at any stage below. And we've taken the view that it would be contrary to the practice of the board to allow an entirely new point to be raised for the first time at this level.
My Lord, may I, in any event, do the introductions and, with your permission, indicate how we had proposed to argue the matters?
Of course.
So, my lords and my ladies, I am Georgia Gibson-Henlin, Queen's Counsel, and appearing with me for the appellant is Andrew De La Rosa, and we are instructed by Francis Gray. Appearing for the respondents are Mark Imrie and Ms. Gemma Freeman. My Lord, what we had in mind was that I would have argued the application and, if granted, the substantive grounds. And in the event, as has now happened, that the court refused to leave, my friend, with your permission, would be addressing you on the original grounds, which would be 1, 2, 3, and 7. So with your permission, my Lord, we'll proceed in that order.
Certainly.
Lords, I'll take grounds 1, 2, and 3 together for the reasons that are already set out in our case, and that is that they are necessarily related. And all of them, and this, to put it bluntly, is the gravamen of our complaint about the Court of Appeal decision. All of them were influenced by the view, which we respectfully submit was erroneous on the part of the Court of Appeal, that we contended for a situation in which both an obligation to build on the land and the right of repurchase were gone. And your lordships will have seen from our case that we refer to a particular part of the judgment of the Court of Appeal and it's at paragraph, if you just keep our case by, it'll save some time flicking back and forth between documents. It's in paragraph 3. And this was the decision in relation to the question of construction as argued by counsel who appeared at the trial, Mr. Hector Robinson, who by the stage the matter reached the Court of Appeal had taken silk in the Cayman Islands. And what the learned Justice of Appeal, Sir Richard Field, said, I cannot accept this argument if it were soundly based. The result would be...
Paragraph are we on?
Paragraph 3 of the... my Lord, I was doing it from my skeleton argument.
Oh, sorry.
Oh, right.
Or for the written case. So sorry.
Sorry.
It is actually at,
28.
it's paragraph 28 of the judgment.
Yep.
But the extract encompasses everything that we want to put before your lordships about this. I cannot accept this argument if it were soundly based. The result would be that by reason of a series of indulgences granted in good faith by the respondent over a lengthy period, the appellants had become free of the obligation to construct a residence on the property, while the respondent had lost its right to purchase the property if no such construction was undertaken. And what we say is that actually both limbs of that assumption are wrong. And the first arises because what was obviously the case in this development was that there was a scheme of development. In other words, a binding arrangement, not simply between the vendor and the purchaser, but a binding arrangement as between all of the adjoining owners, that there would be certain restrictions observed. Now, we'll see in due course that these restrictions have been applied, we say, very selectively, and in the circumstances of this case, in a way which one can describe as discriminatory against the appellants, Ms. Francis and Mr. Clark, because they are the only parties against whom proceedings have been taken to enforce the right of repurchase. And we'll see how that comes about in due course. But, my lords, for this purpose, it's helpful to look at the actual scheme of things as set out in the documents of title. And they are contained in Core Bundle 2, starting at page 200, and it's right at the front of that bundle, Core Bundle 2, starting at page 217. And it's, in many respects, a mercifully short agreement. I'll just step through the relevant provisions with you, if I may, starting at page 219. Clause 5. The purchaser acknowledges and agrees that it is under an obligation pursuant to the restrictive agreements, and we'll see what those are in a moment, to commence and diligently proceed with the construction of a residence and ancillary buildings, landscaping, and other development works on the property, in all respects subject to and in accordance with the restrictive agreements, the construction work. And then there are certain specific covenants about who is to be engaged to carry out the building work, building approval. 5.3, the construction works will be carried out with all reasonable speed in all respects in accordance with the restrictive agreements, and the building contractor will undertake the construction works as principal. Now, pausing there, what one sees is a not entirely consistent set of obligations in relation to this. The vendor focuses on what became Clause 6.2, and if you look at starting with Clause 6.1, this is the recognition, the explicit recognition that there is a scheme of development. The purchaser acknowledges and agrees that the property comprises part of the development and that it is or will be subject to various restrictions, guidelines, and regulations from time to time in force, which the purchaser agrees are necessary for the upkeep and management of the development. In particular, and in consideration of the vendor agreeing to sell the property, the purchaser agrees with the vendor as follows, so that the same shall survive completion. I needn't trouble you with A, B, and C on the next page, the critical provision, as it was originally constituted, is Clause 6.2. And I'll just read that. The purchaser agrees so that the same shall survive completion, that if for reasons beyond its control, including acts of God, it has failed either to commence construction of a residence on the property within 18 calendar months of completion, or to complete such construction by the date being the third anniversary of the completion date, both pursuant to the restrictive agreements, then in either case it will, upon receipt of a written notice from the vendor requiring it to do so, sell the property back to the vendor at a price equal to the purchase price, plus the value of the construction works, if any. And then there's a definition of what the construction works comprise. Now, under this provision, the first date, the date for commencement of construction was the 8th of November 2010. The date for completion of construction was the 8th of May 2012. And we'll see in a moment that particular obligation was varied to extend the period of time in both respects. Clause 6.3, purchaser will not transfer the property to any third party without that third party having first entered into an agreement with the vendor in similar terms to clauses 6.1, 6.2, and this clause 6.3, and further consents to the vendor registering a caution, which the vendor agrees to remove immediately upon completion of the construction work. So the scheme of things was that there was a date for commencement of construction and a date for completion of construction. There's no dispute that neither construction didn't commence within the period of time contemplated by this clause, nor did it commence within the period of time contemplated by the amendment of the clause, which we'll come to presently. If you just look at page 223, clause 12, purchaser may not assign this agreement without the prior written consent of the vendor, such consent not to be unreasonably withheld, provided such assignee completes to the vendor's satisfaction a new application for membership in the form or substantially in the form completed by the purchaser. So again, another obligation that is binding on a transferor from the original purchaser. The covenants in question begin at page 229. And I'll draw your attention to certain of these that are relevant for present purposes. Covenant 2, subdivision combination. The property shall not be subdivided. It may be combined with one or more adjacent properties, provided that all the covenants, restrictive agreements, and stipulations herein contained shall then apply equally to the property so combined. So in other words, the scheme here was to ensure that every plot was built on. That was the original scheme. As you know, from the written cases, this was departed from in a significant number of cases, including by allowing certain adjoining lots to remain vacant as so-called garden plots. Clause 4 over the page buildings and buildings plan approval not to commence any construction of the property without complying with the following provisions. And the first provision is a provision which requires the guarantee company to give its consent to a building plan. 5.
Why are we looking at these? Is this, we're not directly concerned with the details of these covenants, are we?
Not that particular covenant, no, but I'm going to come back to one of the covenants which I'm going to show you in a moment. But just for
the relevance of the covenants is what?
The relevance of the covenants is that these define the scheme of development.
Yes, I mean, there's no doubt that it is a scheme of development.
Yes.
Yes. I mean, does this go to your clean hands point?
In due course, yes. Yes. Covenant 5, no building other than a dwelling house. And then if you look over the page to page 231, the property shall not remain unbuilt on for more than 18 months from the date of registration of these covenants, and construction shall be completed and the dwelling ready for occupancy within a reasonable length of time thereafter, and in any event, within 18 months from the date of commencement of construction. Now, that's the covenant as between adjoining owners. The covenant as between vendor and purchaser is something quite different, and that only has effect in relation to, as it has developed, in relation to the right of repurchase. But you see immediately that there's a discrepancy here, which, not explained in the evidence, why there should be this discrepancy. And I dare say my learned friends, Mr. Imrie and Ms. Freeman, are going to say in due course, well, these covenants aren't relevant, but why the discrepancy? Why the difference?
To be clear, the discrepancy you're pointing to here is what precisely?
The covenant is clear in terms that construction has to commence within 18 months, and then construction has to be completed within a reasonable time, in any event within a further 18 months. So one was looking at a 36-month period. What I showed your lordships in relation to the repurchase agreement between vendor and purchaser is that there's a different period, two different periods specified. I gave you the dates in November. Yes, 8th of November 2010 and 8th May 2012. We've got a different set of obligations here. So immediately, so far as its obligation to other owners under the scheme of development, the purchaser is under this obligation, but there's a different obligation in relation to the right of repurchase.
Just so I can be clear, is this because the 1 in 6(2) operates from the completion of this transaction?
Yes.
And the one in at the top of page 231 operates from the date of registration of the covenant. Is that
Yes.
what you're saying the discrepancy is?
And also,
Well, the discrepancy actually becomes clearer when we come to the deed of variation in 2011, because instead of 18 months from completion, from registration, and then 18 months on from registration, 18 months from the date of commencement of construction, we have different periods introduced. So we have different
So
obligations.
it's also the commencement of construction rather
Yes.
than the two stipulated periods in 6(2) that you're pointing to?
Yes,
Right.
yes.
And how are you going to say that matters?
Well, it places the purchasers under what turned out to be inconsistent.
Well, I mean, no, but if they didn't. This one wasn't held. No one's trying to enforce this one, as I understand it. So the one they are trying to enforce is the 162.
Yes.
So why, if no one's trying to enforce the other, what's the problem?
Well, it's an unexplained incongruity in the scheme of things, because if the essence of this is that we have a scheme of development, we have two different sets of obligations, one of which only arises as between vendor and purchaser. The substantive obligation, in my respectful submission, is as between the adjoining owners, because this was a scheme which was purportedly, on the respondent's case, created so that the development would be built out as it was contemplated to be. As we will see, that didn't simply take place because of variations that were introduced in the case of individual plots. But what I want to show you, the last two things I want to show you in this set of covenants, if you go to page 236, enforcement. First paragraph, if the owner of any property in the development shall violate or attempt to violate any of the covenants herein, it shall be lawful for any other owner within the development to pursue any proceedings at law and in equity against the person violating or attempting to violate such covenants, either to restrain him from such violation or to recover damages or both. And then clause 20, and then the second part of that provision, although the transferor and the guarantee company may enforce the covenants contained herein, they shall not be obligated to do so. Any person, including the transferor, who shall bring successful legal proceedings to enforce such said covenants shall be entitled to recover his costs, etc., etc. And then amendments, because I think my learned friends would want me to point this out at this stage. These covenants may be amended as follows: by the transferor or transferor's successor in title, so long as it owns one or more lots in the said development, or by written consent of the owners of a 2/3 majority of the residential properties in the development. Just coming back to clause 6.2, it's right to point out, and clause 6.2 is back at page 220. If your lordship looks in the middle of that passage, where it defines the two things that we call the trigger dates, failure either to commence construction of a residence on the property within 18 calendar months of completion, or to complete such construction by the date being the 3rd anniversary of the completion date, both pursuant to the restrictive agreements. Yes. And the same applies to clause 5, back one page, where it is said, in all respects, subject to and in accordance with the restrictive agreements. And the restrictive agreements are the covenants that I've just been showing you.
Where is that said?
Well,
Where does it define them as being the covenants?
Lord, it's at page 218.
But it says the restrictive agreements mean all the restrictive agreements to which the property will be subject. I mean, it would make sense, but it doesn't actually say it.
Well, yes, but it's clear enough that the restrictive agreements to which the property will be subject to, as the same, are attached to the draft transfer. The draft transfer is at page 200, starts at page 227, and the covenants are next to that. And those are the covenants that are meant to be registered.
Okay. Yeah.
And then we come finally to the deed of variation, which starts at page 269. And the variation to the agreement is at page 270. Contents of clause 6.2 are deleted, and the following inserted in its place, and it's in broadly the same terms as the original 6.2, except that the two dates, it has failed either to commence construction of a residence on the property by 9th January 2012, or to complete such construction by 18 months thereafter. Then, in either case, it will, upon receipt of a notice, and so forth. And then I think my learned friends would want me to draw your attention to 4.2. The contents of clause 18 are varied by the inclusion of the following new clause 1810. All rights conferred by this agreement are additional to and without prejudice to all other rights and remedies available to the vendor, and no exercise or lack of exercise of a right constitutes a waiver. Yes. Yes. The question my Lord asked about how to know which covenants are being referred to, there is in fact an admission in the evidence on behalf of the respondent. That is at core bundle, it will be core bundle 2. It's just a little bit further on in this bundle. at page 286. At paragraph 5. And you will see that what this was the respondent's sole witness, Mr. Joseph, and he relates the background that he had, in 5th of January 2009, I attended Ms. Janet Francis' office for the purpose of giving her information regarding the land she was interested in, together with the applicable covenants for sale. The covenants that I provided to Ms. Francis are very similar in terms to those of all other contracts of sale within the development. Such covenants have been included in all purchase agreements for properties at VDM since about 1995.
Yes, I'm not sure this is the point. I mean, in fact, in the revised clause 6.2, the reference to the restrictive agreements has disappeared, and we just have the date. So the point I was querying doesn't really arise, as far as I can see.
Yes, I think that must be right. But clause 5, of course, wasn't varied at all. So you still have the interconnection between the restrictive agreements and the obligations in the contract of sale enduring.
But I mean, the position is that clause 5 was more onerous than the revised clause 6.2, wasn't it? I mean, it would have been a tighter time limit.
Yes. Well, going back to clause 5 of the sale agreement back at page 219. Again, it's saying that the purchaser agrees that it is under an obligation pursuant to the restrictive agreements to commence and diligently proceed with the construction of a residence and ancillary buildings, landscaping, and other development works on the property in all respects subject to in accordance with the restrictive agreements. And if your lordship goes back to page 287, again, Mr. Joseph's witness statement, 287, the covenants for sale form part of the defendant's agreement for sale as defined below and were registered with the land registry. Among the covenants was a restrictive covenant which provided that the property and that you have that being that obligation.
That's clause 5.
That's clause 5, yeah.
I mean, you made the point there's a difference between the two, and
Yes.
no doubt you'll explain whether it matters at some point.
Yes, I'll come to that in due course. So that is the contractual position as it stood in as a result of the deed of variation in 2011. But my substantial points, really two, on this particular aspect of the case. And again, I'm coming back to the supposition that the court below made about the impact of these arrangements. First of all, there was an obligation to build. There was no question of the defendants below, appellants here, somehow escaping an obligation to build. So the first limb of the Court of Appeals approach to this is simply wrong. Now, to a property lawyer, the existence of a scheme of development on this land is obvious. It's in the documents of title. It's obvious because it is the sort of arrangement under which, if the thing is to have any efficacy, adjoining owners have to have rights as against each other, right? They're not obligated to enforce them, but there are rights that could be enforced if the adjoining owners saw fit.
So is your point that even if VDM can't enforce an obligation to construct, the adjoining neighbours can?
Yes,
Okay.
indeed, indeed. And one must bear in mind that at the time that this matter came to trial, before Madam Justice Mangatal in Cayman, VDM, the vendor, had ceased to have any interest in this development. It had sold the last land that it owned, so that its only financial interest in these provisions was what we say is the potential windfall of being able to acquire a property that was appreciating in value, and in the end appreciated in value considerably, at the original purchase price, which, however one looks at it, has, in the circumstances of this case, severe consequences for purchasers who, of course, borrowed money to buy this, and it's in the evidence, and it's not disputed. They borrowed money on mortgage to acquire this land. They've paid the mortgage year in, year out, as this dispute has unfolded. And the appreciation value of the property is now having been acquired for just short of $500,000, is now at least 50% more. And if the purchaser, if the vendor is able to reacquire the property, then it makes a windfall. Right?
So your disagreement with this part of paragraph 28 of the Court of Appeal judgment is really that they don't, when they say free of the obligation to construct, they mean, well, it's unobjectionable if they mean free of the obligation to VDM to construct, but they're not free of any obligation to construct.
Yes, but the meaning, the obvious, I respectfully submit, the obvious sense of this is that the judges below were thinking there's no obligation to construct. Now, of course, the appellants, Ms. Francis and Mr. Clark, maintain that this was going to be their home. They always intended to construct a dwelling on it. That remains their intention. But of course, they are thwarted in that ambition if the property effectively reverts to the vendor. Now, what we say, and I make no apology for being blunt about this, is that the only commercial interest, the only real interest which VDM ever had in the enforcement of this covenant was to acquire the property, reacquire the property, and sell it on itself at a profit. Much is made in the respondent's case about something which was described in the evidence as a moral obligation to ensure that the development was built out as planned. I respectfully submit there's nothing in that. There is nothing in that. Moral obligation, why would they, having parted with all the plots on the property, why would they seek to enforce against my clients?
But are we concerned with moral obligations?
We shouldn't be, no.
So
no, that's my point.
We could focus on the...
That's my point.
But if we go back to the time when the contract was entered into for the purchase of this plot, it wasn't built out at that point, the development, was it?
No, but it had been...
And so entering into it and keeping this option to repurchase would have had a commercial purpose at that stage, other than just making money on this plot.
My point is that, I accept that. I accept that. My point is that by the time we come to trial, that purpose no longer exists. And the only purpose of enforcement is to recover the property at what amounts to a discount. And what we do say, and I'll ask you to look back at our written case. At Paragraph 7. Because we put it quite bluntly there. The real issue in the proceedings was whether the respondent was entitled to the benefit of that windfall and not whether the appellants effectively escaped an obligation to build. The Court of Appeals' misapprehension of the true position appears likely to account for its finding that an estoppel by convention bound the parties and thereby, as a practical matter, avoided the undesirable result the Court wrongly identified. And we'll come on to ground 3, estoppel, presently. But coming back to what the Court of Appeal thought the meaning of Clause 6.2 was, again, at the risk of repeating myself, I am repeating myself, again, it's against the background of this assumption that this produces an undesirable result, which we think, we respectfully submit, is simply wrong. Now, I don't think, if you look at paragraph 10 of our written case, I think from the respondent's written case, there's really no issue about these 2 points, which arise out of the United Scientific Holdings case. Where no specific time limit for the exercise of an option is specified in the document granted, it must nonetheless be exercised within a reasonable time of the right arising. And that's common ground. So there are 2 questions there. When does the right arise, and when is a reasonable time for the exercise, what is a reasonable time for the exercise of that right? And secondly, as also established in the United Scientific Holdings case, the exercise must be strictly in accordance with the terms granting it because, as Lord Diplock said, the Lordships have the specific reference there. In accepting such a fetter on his powers of disposition of his property, the grantor needs to know with certainty the moment when it has come to an end. So we come back to Clause 6.2, and I think it's common ground that there were 2 potential trigger dates, 9th of January 2012, and 18 months after that date, falling on the 9th of July 2013, and this is the position that arises under the deed of variation. Now, pausing there, the Court of Appeal, again apparently influenced by what it thought was the undesirable result of finding to the contrary, found that the right had been exercised by a notice given in October of 2013. And there's no doubt that construction had not commenced by that date. Our difficulty with the way the Court of Appeal approached this is that essentially they reformulated the respondent's case for it on the hoof, as it were, in the course of the hearing in 2 respects. One was their conclusion as to the trigger date and the notice effectively exercising the option, and the other was to say that there was an estoppel by convention binding the parties to a particular arrangement. Now, pausing there, any advocate knows that it's an occupational hazard that a court will consider alternative formulations, will consider alternative constructions, so forth and so on, and none of that is objectionable, except in a case such as this, where it flies in the face of the contemporaneous documents and respondents' pleaded case. Now, we can look at the the two notices which are in bundle, I think it's bundle 3. No, I'm sorry, it is, yes, it is bundle 3. Beginning at page, first of all, what the respondent said was the operative notice is at page 781.
Sorry, say that again.
Page 781 of bundle 3. And it's a notice exercised by a letter of that date. And it's dated the 10th of July, 2014. Refer to previous correspondence in relation to this matter, and in particular to the agreement for sale, the deed of variation, your ongoing correspondence with Mr. Joseph. Pursuant to Clause 6.2 of the agreement, as varied, you had until 9th January 2012 to commence the construction of a residence on the land. Additionally, and pursuant to that clause, you both agreed that failure to do so would constitute a right of VDM to purchase the land back from you at a price equal to the purchase price, and it's set out, and this is the notice. This letter serves as a notice by VDM pursuant to Clause 2 of the agreement to purchase back the land back from you at the purchase price of $462,450. And they say we will provide you with a transfer and so forth and so on. Now that was in similar terms to the earlier notice at page 747. And again, it's in substantially the same terms. Pursuant to Clause 6.2, you had until 9th January 2012 to commence the construction of a residence. Now, what is being said in both notices, the 2013 and 2014 notices, is that it's the default in commencing construction by the 9th of January 2012, and not the later date, not failing to complete construction by July of 2013. It's the earlier of the two dates. So that when the Court of Appeal concludes that, well, actually the trigger date is later. The trigger date is 18 months, the extended period of 18 months for construction to take place. What they were doing was reaching a conclusion which is contrary to the contemporaneous documents. One takes the vendors as meaning what they said in both of these documents. In other words, that your default was in not commencing construction at all as long ago as the 9th of January 2012.
Do you also say that the first notice exhausts the option holder's rights because the option is an offer which was accepted and then the offer has gone? There's nothing else to accept back when you get to 2014.
Yes.
Right, can you just expand that? I don't think that was in your...
The effect, the effect of the option is to create a contract for the purchase and sale of the land at a fixed price, as at the time of the first notice.
10th July 2014.
No, at the time of the first notice, 2013. That's the notice.
The October 3.
That's at page 747.
Yeah.
So what one then has is an agreement, a contract for sale of land coming into existence. Now the respondents no doubt say, well, all of this was subject to a a series of informal arrangements about extension of time, but there's their contract.
Yes, but even if you've got a contract which stipulates, allows you to enforce, you can waive enforcement or extend time. Or, I mean, does it affect? I mean, I see the point you're making, that technically there may have been a contract in place on 14th October 13, and so the notice of 10th July 14 was a sort of, well, it's not exercising an option which has already been exercised.
Yes.
But still, it's obviously extending time and giving you a date for completion. So
Yes, but
does it make any difference?
Again, it can't go on. It's exhausted the right which the respondent is relying on. It's exhausted the right to repurchase the property at a given.
But you accept that even having, if he's exercised his right, then he'll be able to allow you more time as an indulgence under that contract.
Well, but it simply can't go on for as long as...
Well, the question then would not be whether it's a reasonable time for exercising the option, but whether it's a reasonable time for enforcing the contract which the option has brought into effect, which may be a different question.
Well, in either case, there's a question whether the right has lapsed by virtue of what followed. In the Court of Appeals approach to this, you didn't have I respectfully submit it's obvious that if you exercise an option, you can only do so once because it doesn't permit you to make successive attempts to exercise the same right. If you were successful the first time, and their position must be that they were, then you've got a contract in existence.
Then surely the issue becomes one for the court, really. You've got a contract, a completed contract, which you're entitled to specific performance of. Then it's really a matter for the court to say, well, has there been late fees? Has there been unreasonable delay in enforcing it?
The difficulty for the respondent is that it didn't sue on that contract. It sued on the 2014 purported exercise of the option. And in the course of the argument before the Court of Appeal, there was a suggestion that perhaps they wanted to amend their case. It wasn't taken up. And what we were left with was the Court of Appeal concluding on an erroneous basis that the option had actually been exercised, and that it was open to the respondent to serve a further notice in 2014. Now, if the start date is January 2012, right? Either an exercise in October of 2013 or July of 2013 is on no account, in my respectful submission, a reasonable time. And that really derives from fundamental principles that if this is an option, it has to be strictly complied with, failing which it lapses, and we don't have anything other than in existence for the respondent to purport to accept when on its own case it did so.
May I just ask, your submission is that the Court of Appeal fell into error in pointing to the 9th of July 2013 date for two reasons, as I understand you. But please correct me if I'm wrong. First, because on the proper interpretation of the contract, having failed to start to build by the 9th of January 2012, the second date effectively became irrelevant.
Yes.
And secondly, because the letter pointed to the earlier date in any event. Yes. So you have two limbs to your submission. Is that right?
Yes. possibly a third link, because of course the respondent's pleaded case at trial was in line with what I have said when the right arose and when it was exercised. And for the sake of completeness, you can see that again. It's in the same bundle, Bundle 3, page 670. And it's paragraph 13. And it's in plain terms. On 10th July 2014, the plaintiff sent a notice to the defendant exercising its right to repurchase the property. So the clear position we have is that on the contemporaneous documents and on the respondent's pleaded case, it regarded its right to repurchase as having accrued as at 9th January 2012, and the option as having been exercised only as at 10th July 2014. And there's really no good reason, and the Court of Appeal didn't advance any in my respectful submission, for concluding that the position was different from the respondent's own position, as I say, in the contemporaneous documents and its pleaded case. Now, however you look at it, let us for the moment, leave out of account the question of the contract that was formed. Supposing that the option subsisted. The trigger date is still January 2012. It's not exercised even at the earliest, until some 18 months later. And even later, nearly 30 months, if we're talking about July of 2014. On no account, in my respectful submission, could that be regarded as a reasonable time.
Well, the Court of Appeal, as you know, dealt with this in paragraph 25, and their view was that even if the trigger date was the 9th of January 2012, VDM would have been entitled to a finding that the 14th of October 2013 notice had been received by the appellants within a reasonable time, and explained that this was because of the evidence that throughout the intervening period the appellants had been giving assurances about their intention to commence construction, and the respondents had been content to allow them further time in the light of the information that they were being given.
Well, again, if the respondents' own position was that they didn't exercise the right until July of 2014, then the Court of Appeal's logic is neither here nor there, because that's an extra period of 9 months.
Well, they're saying they're saying that assuming that you're right, even if the relevant dates are January 2012 for the trigger date and October 2013 for the service of the option, for the service of the notice triggering the option, they say the intervening period was not beyond a reasonable time because of their findings as to the behaviour of the parties during that period. So, I mean, it's an alternative. So it's effectively an alternative basis for their conclusion that VDM was entitled to specific performance. that even if you were right, they were still entitled to it.
Well, again, that was not the case, that was not the pleaded case, nor was the next point we're going to come on to, which is the method the Court of Appeal found to cover the position that my Lord has described, which was this estoppel by convention.
Yeah.
Can I just, before you come back to that, I just want to make sure I understand what's happened to your point on Covenant 5, because by the time the case comes to trial, which is into November 2014, at least the case is commenced, what rights would the other residents have had? Because there, under Covenant 5, the time for commencement or completion hadn't been extended.
No.
And so, under that, it should have been, assuming the covenants were registered somewhere near the time of sale, which is
Yes.
May 2009.
As it was meant to be done.
As meant to be done.
And in fact...
Then they would have had, the completion time would have been sometime in 2012. So, and all these points you're making about unreasonable delay would have applied to any other resident who had tried to enforce, having done nothing about it for 2 years.
Well, the point never arose because the...
No, but your assumption that the Court of Appeal were wrong to assume that this was the effective way of enforcing assumes that the other residents would have had extant rights, but if they failed to do anything for 2 years, there must be some doubt about that, mustn't there?
Well, no one suggested that there was any prejudice to the adjoining owner's rights in that period of time. It simply wasn't considered at any stage in these proceedings what the adjoining owners had a right to do.
No.
And their position...
But no one suggested to the Court of Appeal that somehow there were effective rights for the adjoining owners to do something to them.
I'm sorry, my Lord.
Well, did anyone suggest to the Court of Appeal that there were effective rights for the other residents?
No. That is part of the difficulty, that no one recognized that there was still a subsisting right on the part of the adjoining owners to enforce. Now, your Lordship is quite right. It might have been defeated by late G's, depending on the circumstances. But in a case where there's no inquiry, no recognition of that right, it's impossible to say that it must have fallen away.
Yeah. All right, thank you. Anyway, we're going on now to the estoppel point.
Sorry, can I just check before, when you were just about to introduce that, I think you said that the reason that the Court of Appeal found to cover the period mentioned in paragraph 25 was estoppel.
Yes. And it goes on. It's later on.
Later.
It's later on in their judgment. It's paragraph 29.
But they've moved to a different point at that point. They're saying that it was received within a reasonable period. That's what 25 is about, isn't it? Assuming that we're approaching estoppel and reasonable period of time as different points.
Yes.
This is about reasonable period of time, isn't it, paragraph 25?
Yes. 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 I think that's... See. Well, as we're on that particular page, on that part of the judgment, as the lady's right, this is concerned with what is a reasonable time. But the court then moved on to consider in paragraphs 28 and 29. 28 you've already seen because that's cited in our written case. 29. In my judgment, it is clear that after the 14th October 2013 notice down to 10th July 2014, the parties proceeded on the basis that there remained an obligation on the appellants to construct a residence on the property, whilst at the same time VDM continued to have a right under amended Clause 6.2 to purchase the property if things dragged on over long. There was, therefore, in my view, an estoppel by convention to this effect, from which the appellants cannot depart, with the consequence that the 10th July notice was an effective exercise of the option. And that does bring us on to the question of estoppel by convention. And you've seen from our written case that although there were allegations introduced by way of reply by the respondent to say that they had exercised forbearance in relation to the appellants, there was no pleading of any particular form of estoppel, let alone estoppel by convention. Again, this analysis was only surfaced in the course of the Court of Appeal hearing itself.
The only reason why they're raising the issue of estoppel seems to be because of their view that it's the 10th July 2014 notice that's the important one. I mean, if the 2013 notice is the one that's relevant and the contractual rights were constituted in favour of the current respondents at that time, then the question's a rather different one, isn't it, as to whether effectively they had abandoned their rights by their conduct subsequently. And then one would be looking at what conclusions you draw from the representations being made on behalf of the appellants and the willingness of the respondents to allow them further time.
Yes. In my respectful submission, well, the Court of Appeal chose to approach this as an estoppel question and not as an acquiescence or waiver, or waiver question. And that's the conclusion that we have to deal with. And again, I say that this arose only in the course of the hearing. None of the authorities that we've cited, both sides have cited in relation to estoppel by convention, were canvassed before the court. And so there was no focus on whether there was any specific criteria that had to be met in this respect. It was simply estoppel by convention is raised by the court, and eventually the case is substantially decided on that basis. And our third ground of appeal is that this was not a legitimate approach on the part of with all due respect, was not a legitimate approach on the part of the court, because it never addressed its mind and wasn't invited to address its mind to what are the criteria for an estoppel by convention to arise. Now, that issue has been ventilated in this court and in other courts as a and there's no significant difference between our side and the respondent as to what, except in one particular respect, as to what the criteria are. And they're set out in Section 3 of our written case. And I'm going to invite your lordships to look at paragraph 19, which sets out the criteria as explained in what I acknowledge is a first instance decision and an unreported decision, but it's the best encapsulation one can find, in my respectful submission, of what the relevant principles are, and that's the bench dollar case. And this was a decision of Mr. Justice Briggs, as he then was, and he set out 5 criteria, 5 main points. First of all, it is not enough that the common assumption upon which the estoppel is based is merely understood by the parties in the same way. It must be expressly shared between them. That's point 1, and I'll say straight away that in our respectful submission, the respondents, the case on estoppel by convention falls at that first hurdle. Secondly, the expression of the common assumption by the party alleged to be estopped must be such that he may properly be said to have assumed some element of responsibility for it in the sense of conveying to the other party an understanding that he expected the other party to rely on it. The person alleging the estoppel must in fact have relied upon the common assumption to a sufficient extent rather than merely his own independent view of the matter. That reliance must have occurred in connection with some subsequent mutual dealing between the parties. Some detriment must thereby have been suffered by the person alleging the estoppel, or benefit thereby have been conferred on the person alleged to be estopped. Now, if we take the first criterion, a common expression which has been expressly shared between the parties. Yes, there were any number of informal exchanges of correspondence about what the appellants were doing to advance construction on the land that was owned by them.
But don't we have to define what this common assumption was?
Yes, yes. The difficulty in this case is that no definition of what the assumption was ever put.
Well, could I put it this way? Wouldn't it have to be a common assumption that the respondents could serve a second notice exercising the option despite having served the first?
Yes. Yes,
And would it have to be that?
In the events which happened, in my respectful submission, yes. But, and that's a consequence of the way in which the respondent has approached this throughout. But the only evidence there was, actually there was no evidence of a common assumption expressly shared between the parties. What the Court of Appeal was doing was inferring it from a course of conduct. No one actually put to Ms. Francis, who was the witness for the defendants below, no one actually put to her any question designed to elicit an acknowledgement that there was a common assumption expressly shared. And the closest we say that the respondent ever got to that is set out in paragraph 25. Ms. Francis was not cross-examined on the existence of any common intention of the kind the Court of Appeal concluded existed. And then, again, instead, at trial, one primary subject of the cross-examination of Ms. Francis, paragraph 26, was an attempt to demonstrate that she and her co-purchaser did not have a realistic prospect of raising the finance. I'll come back to that point in a moment, if I may. Respondent didn't actually get a finding to that effect. And then over the page, she was asked by my learned friend, Mr. Imrie, the respondent was insisting on comfort from you so that you could determine whether to take action to repurchase your property or allow you to continue with the project. That's exactly what this email is saying, isn't it? And that's an email in February of 2014. And Ms. Francis disagreed with that suggestion. And indeed, on the part of the respondent itself, its witness, Mr. Eric Joseph, never said, our common assumption expressly conveyed to us was that we could serve a second notice. We could proceed to enforce. I can't speculate on what question in cross-examination could have been asked, but it might have been along the lines of you understood and you believed that the respondent understood that they were continuing to have their right of purchase. I can't speculate on what the answer to that would be, but in the absence of it, in my respectful submission, we simply have nothing that founds an estoppel within the criteria that have to be applied. And again, I say, there was no argument addressed to the Court of Appeal about the criteria that have to be satisfied. So coming back to Mr. Justice Briggs's formulation, again, we say it fails at the first hurdle. This is paragraph 19. There has to be an assumption of responsibility for it in the sense of conveying to the other party an understanding that he expected the other party to rely on it. Well, that's fairly exacting. The expression of the common assumption must come from the party alleged to be estopped to the party who's relying on the estoppel, and it must be such that it conveys an understanding that he expected the other party to rely on it. Well, we don't have anything of that kind. Factual reliance, well, we don't get to that. The criteria 3, we simply don't get to that in the facts of this case. Or 4 or 5. So the result is this unsatisfactory position that the Court of Appeal decides this case substantially on a ground that wasn't raised, wasn't addressed by either of the parties, in circumstances where a witness was never given the chance to answer a direct question to the effect that this was the position. Would your lordships give me a moment? Lords, I've taken that briskly because it's a fairly stark position. If we're right, and there's nothing in the evidence that discloses that this was ever put to the first defendant, Ms. Francis, that, in my respectful submission, is really the end of the matter. There's no estoppel, established. And that linchpin of the Court of Appeal's approach to this simply falls away.
It's interesting that the way the judge in the Grand Court dealt with it was quite different. She found there to be an estoppel arising from the conduct of the then defendants, that effectively they had, well, the way she puts it, they can't take advantage of VDM's good faith forbearance and are stopped from relying on any such delay as a means to avoid enforcement. So she wasn't talking about an estoppel by convention, but simply the conduct of the defendants in seeking forbearance and then being stopped from relying on that forbearance as a reason why the agreement should not be, while the contractual rights shouldn't be enforced. And she dealt with the issue of leaches as well, which was the alternative way it was put, that VDM had delayed to such an extent in bringing proceedings, it would be unconscionable to allow them a remedy of civic performance, and that, of course, was rejected also.
Yes. None of that was approved by the Court of Appeal. They took what was in effect their own course in this respect, and that's the judgment that one has to deal with. And again, it is quite stark. But then, on the other hand, and it may be one of those cases where the appellate court was seduced by the view of the merits that it had. But again, we say that was a mistaken view, because first of all, our clients never sought to escape an obligation to build. Secondly, they never in fact escaped an obligation to build because it was there in the covenants.
Can I just take you to one particular document so that you might be able to help me with it? At page 744. This is just before the service of the first notice. It's the backdrop to what follows. And it's, I think, from the second appellant, isn't it?
Yes.
And in the second complete paragraph, he says that he appreciates that VDL wish to preserve their rights. That's the backdrop to all that follows. A notice is served, but they continue the discussions they'd been having up to that point. We're going to do it, we've got this far, etc. Does that not go to the question of the estoppel and the articulation of the basis upon which they proceed thereafter?
Well, again, the common assumption has to be unambiguous. It has to be expressly conveyed. And of course, you have to look on both sides of the transaction. Saying that they wish, understand they wish to preserve their rights is ambiguous as far as it goes. Which rights, under which part of the contractual?
You have to look at the preceding email from Mr. Joseph at Vista Del Mar, don't you? They're considering exercising their rights under clause 6.2.
Yes, I accept that. Yes.
But that happens because the notice is served.
Yes, that is exactly the point. In any event, it cuts both ways. There would have to be some agreement or understanding that, and not just something unilateral coming, vague as it is, and in the context that Milady has referred to, there would have to be some agreement or understanding that the respondent was able not only to serve the first notice it did, with the consequences that had, but the subsequent 2014 notice. Well, I've taken that fairly briskly with an eye on the time.
Could I just ask you to clarify that in your written case at paragraph 26, you referred to a quote from the cross-examination.
Yes.
And you give the reference CB2 478 479. I couldn't find that particular quote. I mean, don't worry now, but it would be quite helpful if you could identify it at some point.
Well, that in the events which have happened, that really brings me to the seventh and last ground of appeal, which is the clean hands point. And I accept that both courts below were dead against the appellants on that point. Our only point in relation to that is that the wrong approach in principle was adopted. If you adopt the right approach, in our respectful submission, the conclusion is that there was misconduct on the part of the respondents in treating the appellants differently from any other owner on the property. It may help to look very briefly at the relevant authority that we refer to, which is Snell's Equity, which is in the Authorities Bundle Part 2, and it's behind tab 33.
What's the electronic page, please?
The electronic page will be 2441. Does your lordship have that?
Yes, thank you.
And this is the part of Snell that deals with the maxims of equity. And there are two that are relevant because they're related. 5, he who seeks equity must do equity, and he who comes into equity must come with clean hands. We'll concentrate on 6. This maximum is clearly similar to the previous one. It differs as it looks to the past rather than the future. Again, the question is whether any general moral culpability can be attributed to B, the party seeking relief, but is rather whether relief should be denied because there is a sufficiently close connection between B's alleged misconduct and the relief sought. The maximum is therefore applicable only in relation to conduct of B, which has an immediate and necessary relation to the equity sued for, and is not balanced by any mitigating factors. The maximum is closely related to the common law maxim extirpi causa non oritur actio. At common law, this maxim has been rightly criticized, etc. And then I must draw your lordship's attention to the next paragraph on the page. Although the maxim, like its common law, equivalent to common law, must be viewed with great caution, the instances of its application serve as useful illustrations of the circumstances where particular policy considerations have been sufficient to deny recovery, which would otherwise have been permitted. And that there are some examples given. And the only one which has even a remote relation to the present circumstances is in the context of forfeiture of a lease. But the question is whether there is an immediate and necessary relation to the equity sued for. The equity sued for in this case is specific performance of a right of repurchase. Now, the way in which the development actually progressed, and there's no dispute about this, is that there were numerous instances where the covenant on which the respondent relies, although invoked, was not enforced. And what we have instead is a number of plots of land, despite the covenants binding between owners, requiring building, and building on each parcel of land within a specific period of time. Despite that, the respondent released, insofar as it was able to do so, various purchasers from the obligation to build so that they could have what were called garden lots, vacant lots. This in the context of a scheme where it was intended that every lot was built out. We then had circumstances in which purchasers who, in the event, were not themselves able to commence or complete construction. I think, in fact, there was no case in which there was incomplete construction. There were cases in which construction was never started. It releases them to the extent of allowing to sell their properties in the open market. Neither of these things, and in particular a sale in the open market, is ever offered to the respondents. The sequence of events is quite telling, and I'm going to ask your lordships to look at the agreed statement of facts and issues, which will be in bundle 4.
Assuming that you're right, that the respondent has treated the appellants less favourably in respect of their breach of contract than it's treated other people who have committed similar breaches of contract, does that amount to misconduct within the meaning of the clean hands doctrine?
Well, what I was about to come on to is the exact sequence of events, which is set out in the agreed statement of facts and issues. And the electronic page with the relevant part is page 1523. In fact, it's 1524.
Which paragraph?
28.8. Well, start with 28.7. On the 29th of April 2014, on the 18th of June 2014, Mr. Joseph wrote to the appellants asking what progress had been made in obtaining the necessary finance. Mr. Joseph explained that it was very important for VDM to be sure that sufficient funds were in place for a successful completion of construction. On 19th June 2014, Ms. Francis responded to Mr. Joseph, saying that the quantity surveyor's report required by Bank of Butterfield would be available on the 20th of June, but there was no further update on financing. And then on the 8th of July 2014, the appellant submitted an application for finance to the Bank of Butterfield. Now, pausing there, the respondent knows, because it's been told by Ms. Francis, that a condition, the preparation of a quantity surveyor's report for the application for funding, is about to be satisfied on the 20th of June. And the respondent knows that the appellants are going to apply for finance, as they did on the 8th of July 2014. It's 2 days later that the second notice to repurchase is served or is sent to the appellant. So the respondent, knowing that finance is about to be applied for, effectively preempts it by serving a notice, because and the timing is quite extraordinary, in the sense that all this time has passed. At every stage, the appellants have said, well, we want to build, we're proceeding to build, we're doing this, we're doing that, now we're applying for finance, and suddenly the next notice comes in. And as your lordships will appreciate, and it's in the evidence, and I can take you to it, the effect of having a dispute over ownership of the property which is going to form security for the mortgage is effectively to kill the possibility of raising that finance, to make it dead in the water. So, misconduct, viewed against the background of the extent to which the respondent allowed departures from the covenants, allowed departures that effectively prejudiced the position of other owners, who had a right to insist that every plot be built on.
Well, it weren't being prejudiced, were they? Because they still had their own right if they chose to enforce it. Is that not right?
Well, if they chose to enforce it, yes, yes, yes. Would your lordships give me a moment? All right. Well, my lords, if your lordships would go back to Core Bundle 2, page 236, this is clauses 22 and 23, the enforcement covenant and the amendment covenant.
I beg your pardon, which page is that?
It's 236.
Thank you.
I've already taken you to both, but it's clause 23, amendment of covenants. By the transferor or the transferor's successor entitled so long as it owns one or more lots, or by the written consent of the owners, such modification shall take effect when duly executed and filed with the registrar of lands of the Cayman Islands. Would your lordships give me a moment? So, my lords, although one isn't concerned with moral issues, I'm sorry, my lord. I've partly misunderstood my instructions. The reason for taking your lordships to clause 22 and 23 is that modification shall take effect when duly executed and filed with the registrar of lands of the Cayman Islands. No modifications relating to garden lots have actually been registered. And there is a schedule which was prepared on behalf of the appellant. That's a table. It's at CB2, pages 319 to 322. And this is a table which was annexed to a witness statement made by Ms. Francis. And it goes through each of the, she examined the register of title to each of the lots in question. And your lordships will see that on the far side, the notes, and this is drawn straight from the register of title, and I don't think there's any dispute as to its accuracy.
I'm sorry, I beg your pardon. Could you give me the page again, please?
319.
319, thank you.
It's 319 to 322.
Yeah.
And you can just look down the right-hand column and see what it discloses. First of all, we have Mr. Freytag, who was the principal of Vista Del Mar. He wasn't subject to any covenants. Secondly, there's a Mr. Harris, Construction commenced 6 years after the required 18 months. In the case of 2 lots, again, Mr. Freytag, no restrictive covenants. Then Mr. Bordessa, formerly registered at 10A 182, now combined with former lot 244 to be 344, no construction started. And so it goes on. So there are all these variations, including construction either not being commenced on time, or if it was commenced, many years later. All of these indulgences granted by the respondent to other owners. But we come to the point at which VDM has sold the last parcel that it owned on the development. It has one subsisting right to repurchase. That's against the respondent, the appellants, and it exercises that just at the point when they are seeking finance. Now, there is perhaps an explanation for this, and your lordships will have seen it's rather graphically illustrated at the end of the respondent's case. And if your lordships will look at that, that is the electronic document number is 1655, but it's paragraph 96 of the respondent's written case. And it starts, if your lordships have that, it starts this way. The appellant's written case seeks to portray VDM as a ruthless development company motivated purely by the prospect of commercial gain at the appellant's expense. At base, VDM is, of course, perfectly entitled to take that approach. However, that is not what happened here, and counsel are instructed to draw the court's attention to the following points at the outset. Well, they won't need to, because I'm doing it now. And this is obviously being done on instructions because it reflects VDM's own view of the case. Number one, they did consider that they were acting in the best interest of the development as a whole, and always acted with courtesy, politeness, and respect toward the appellants and other purchasers. The appellants are both sophisticated and well-resourced individuals with their own property portfolio. VDM's representatives have given the appellants numerous opportunities to repurchase, having been driven to the conclusion that the appellant's assurances would not come to pass. There was no ability by the appellants to commence construction, and they were not going to on-sell the property to someone who could. And then there's a reference to how the litigation has been conducted. It's 96-3. No ability by the appellants to commence construction. As we've set out in our written case, a considerable amount of the cross-examination of Ms. Francis was devoted to trying to demonstrate that she couldn't raise the finance for this project, unlike other projects she had undertaken. And in fact, most of the cross-examination is directed to that aspect of the background. There was, again, no finding by the trial judge to that effect. No finding that the appellants were simply not in a position to raise the necessary finance. So the assumption, which seems to have underlied VDM's own outlook on this, as expressed at the end of the respondent's case, either wrong or it wasn't an assumption that was borne out by the evidence given in the proceedings. And again, I refer back to how quickly they acted once they knew that financing was being sought to exercise or purport to exercise the right of repurchase. Last point, if we hope we can assist in finding the passage.
I found the one which I was asking you about.
Oh, you found it,
Yeah,
right.
thank you.
Well, very well. It's in paragraph 26 of our written case.
Sorry, you want? It's on page 278.
My lords, unless there's anything else I can assist your lordships with, those are our submissions.
Can I ask for a page reference, please? Paragraph 228.8 of the agreed facts and issues. This is the email from Ms. Francis to Mr. Joseph saying that the surveyor's report
Quantity surveyor's report, yes.
is going to be about. This is what you say clicks it over into the developers knowing that
Yes.
they're going to get the finance. So I'd
Yes.
just like the page reference to that email, please.
228. Lady, I haven't got that.
Well, don't worry, in due course.
Yes, in due course. Well, we'll come back. We'll come back to that. We haven't used up all of our allotted time, and as the respondent will be starting early, we'd like to reserve rather more than the 10 minutes that we had budgeted for ourselves for a reply. It depends, of course, on the course of proceedings.
Yes, yes, very well. Thank you very much. And you don't follow. Thank you. Mr. Emery.
May it please my lords, my ladies, very honoured to be able to present today, very humbled at the opportunity and grateful for the time allowed to put forward the respondent's case. I will start by speaking slowly so that my accent doesn't distract from the points that I wish to make. I've been told that I often say the word estoppel as if it begins with an I, not an E, but I assure you we're talking about the same thing.
I'm sure we can cope with an Australian accent.
Well, or a New Zealand one.
Or a New Zealand one.
Or one that it hurts.
Also very well with mine. So.
One that has only been in the Caribbean for 15 years or so and has not yet developed what some of my colleagues have. My lords, my ladies, the suggested order for my presentation was going to be to work through matters in the same way that my learned friend has, starting with the interpretation of the contract, whether the option was exercised within a reasonable time, then moving on to the points on estoppel, try and deal with that as it was pleaded, and then deal with it as it was presented in the Court of Appeal. And it's important in my respectful submission to note that there was a change in the appellant's case between the trial and the Court of Appeal. And that will hopefully put into context the way in which the estoppel argument was pleaded, was dealt with by the Grand Court judge, and then was dealt with by the Court of Appeal when a new submission was made for the first time before the Court of Appeal.
And can I suggest that it would be helpful to us if you were to deal with the case on the deal with the possibility that the option was effectively exercised on the 2013 date. Right.
And then finishing off with the clean hands point, which we've heard very recently from my friend. So unless there was any alternative suggestion, I'll proceed on that basis. The questions of interpretation of the critical clause are quite fully set out in the respondent's written case, paragraphs 6 through to 9, and then paragraphs 28 through to 33. Rather than go through those, I was proposing to address the clause as it stands, and it might be helpful to have that particular document open. It's in bundle 2 of the reproduced record at page 270. Make the submission that the difficulty with limiting the trigger date on which my learned friend relies of the to the 9th of January 2012 is that the language of this clause is written disjunctively, and it identifies two potential events of default or breaches of contract: the failure to commence construction and then the failure to complete construction. And the points we make in favour of that interpretation are that the words "such construction" within this clause refer to the construction of a property on the residence, even if it commenced after the 9th of January 2012. And therefore, the reference to completion of such construction provides a long stop date, not necessarily linked with the requirement to commence construction by the 9th of January. And that is supported by the use of the words either to, the word or in either case. So it's a disjunctive clause. And the interpretation contended for by the appellants in the courts below, in order to have been achieved, would have required a rewriting of that clause. Some examples as to how it could have been rewritten have been included in my written case.
You say, for example, you could waive the first and rely on the second.
We do say that, yes.
But in the event, both notices identified the relevant default as being the failure to commence by 9th of January.
And that's the language in the notice, and we'll come on to deal with that. One of the difficulties with saying anything else is that there would no doubt have been a dispute as to when the time for the completion of construction was to be calculated. And by that I mean one can see the lawyer drafting the notices saying, well, I know that they didn't commence on the 9th of January. Had I attempted to enforce before the 9th of July 2013, I would have been met by the argument, presumably, there's no prejudice because we still have this time in which the completion could take place. So we say that the manner of drafting of this clause, the interpretation that we ask the board to give it, as did the earlier courts, is one that accords with both the plain and ordinary meaning of the words and commercial common sense, including the practical realities of construction of a residential property in the Cayman Islands. And that we get some flavour just from the clause itself because of the reference to reasons beyond the control of the purchaser. And in the courts below, I made the point that the requirement for consent from the planning department, from the building department, and the need for sign-offs to be given sometimes takes much longer than might be expected in other jurisdictions. Now, the effect of that clause, we say, is that if construction of a residence commenced before the 9th of January 2012, it would need to be completed within 18 months of commencement. If construction started after the 9th of January 2012, a waiver was given, extra time was allowed, or did not start at all, the long stop date of the 9th of July 2013, that is 18 months later, would be the second point at which the trigger could occur to exercise the option within a reasonable time.
Well, the thereafter surely refers to the 9th of January 2012.
Yes, that's right, with respect, my lady.
Thank you.
Now, the appellants argued in the Court of Appeal that on their construction, that there was only one opportunity to exercise the option if commencement had not taken place by the 9th of January. And that was a requirement then to serve a notice exercising the option within a reasonable time of that date. And a reasonable time in the view of the appellants in the Court of Appeal was 3 to 6 months after the date. And you'll see this from reading the transcript, which is in the bundle. That then raised a question of what happens if construction did not start on the 9th of January, but instead started with permission at some later time. And it was accepted by the appellants in the Court of Appeal that if construction commenced after the 9th of January, there would indeed be a second opportunity for the respondent to exercise its option if construction was not completed within 18 months.
You say they effectively conceded this point in the Court of Appeal?
Well, they conceded, and this is at the transcript, which is in Bundle 1, page 53, line 289. They conceded that if construction commenced after the 9th of January with the permission of the respondent, then there was a second opportunity to trigger the option. So those are the interpretation points. It's tempting to say the construction points, but when you're talking about construction, identifying it as interpretation makes it easier. We go on then to make some points in response to my learned friend's submissions this morning. And we respectfully say that the fact that the notices referred to the 9th of January date is not an aid to the interpretation of the clause. The second notice, like the first notice, did refer to the 9th of January, but as we'll see, the second notice also referred to the ongoing correspondence that had taken place after the issuance of the first notice. So when it comes to the language of the notices, not an aid to interpretation, we respectfully submit, but give a flavour of what was happening behind the scenes after the first notice was issued, which we will come to. Now, in addressing the point raised by my learned friend this morning about Clause 5 of the Schedule of Covenants, which contains the similar 18-month language. Well, in our respectful submission, that language is not critical to determining the interpretation of Clause 6.2. Clause 6.2 stands and falls on its own, and the presence of a similar but not identical provision in the covenants is of no real assistance. Of course, the covenants or the restrictive agreements do not contain the option to purchase. And there's the argument mentioned this morning that by now, for example, there is a question about whether the covenants could be enforced by the owners, given the passing of time since they were registered. In fact, as we'll come on to see, it's clear that the owners have agreed that Vista Del Mar will have the sole right to enforce the option to repurchase in the building contract. The option to repurchase in the agreement for sale as amended by the deed. And it's not simply in respect of this property, as my learned friend appeared to suggest. There are two other properties still potentially the subject of the exercise of this option. On that basis, we respectfully submit that the Grand Court interpreted the clause correctly, as did the Court of Appeal, with the result that the second trigger date of the 9th of July is the important one, and the issuance of the notices followed within a reasonable time after that second trigger date.
That doesn't deal with the question whether it was open to serve a second notice once the first had been served. Are you coming on to that point?
Yes, I was proposing to deal with that when I dealt with estoppel. And the reason I was proposing to do it that way was because, as I mentioned, the basis on which the case developed was such that the argument made on whether the issuance of the first notice changed the relationship to one of vendor and purchaser was not pleaded by the appellants in the Grand Court, was not the subject of any argument in the Grand Court, and therefore not the subject of any cross-examination as to what the underlying assumptions might have been, and only became an issue in the Court of Appeal. And in my respectful submission, when we come on to look at the way in which that submission was made and the way in which the Court of Appeal dealt with it, the criticisms of my learned friend fall away. And just one point I will make is that there has been no finding yet in this case that the effect, the legal effect of the first notice was to change the relationship from the exercise of an option to the bringing into effect of a sale and purchase agreement. That has not been a finding made to date.
Well, that's not a question of fact, is it? That's a question of law.
No.
Can I just say, do I understand your answer to be saying that the answer to the question whether the second notice was valid turns on the convention estoppel? If there's good convention estoppel, it would have been an assumption between the parties that they would allow a second notice.
Yes.
That's what it is. So it all turns on the, that's why you're dealing with them together. Yes. It turns on the convention estoppel point.
And with respect, to elaborate just briefly on that point, it is the respondent's position that the common assumption is exactly as my lady described it and has just been described now. Alternatively, if we are wrong about that, then the sequence of events which took place after the service of the first notice result in an agreement to abandon the sale and purchase relationship and revert back to the issuance of a second notice.
Right, that's the other way of putting it. But in either way, just elaborating that, the fact the Court of Appeal went into convention estoppel is on the implicit basis that the first notice would have given rise to a relationship of vendor and seller, would have given rise to a contract to sale, otherwise they didn't have to go to convention.
That's right.
Yeah.
I think that's fair, and one can go through the transcript and see the way it came out.
Right.
So it wasn't really in the written submissions, but it was put forward for the first time in that manner, and that's where the discussion about convention estoppel came out, because speaking frankly, the Court of Appeal was saying, well, if you can reach the conclusion that the estoppel that the assumption or agreement between the parties, which they said was implied, had the effect of enabling the respondent to serve a second notice, you can also reach the conclusion that they were able to unagree or change the agreement in relation to the vendor-purchaser relationship. And it was the same outcome.
I mean, if you've got a completed contract in October 13, why couldn't you enforce it?
Yeah.
I think I heard that as if
why
you've
could
got...
you not enforce it? Because, I mean, we're considering two options. One is estoppel by convention, one is abandonment. But the third is that you had a completed contract as at October 2013, and you delayed enforcement for perfectly sound reasons. What was to stop you enforcing it?
Yeah, but effectively, if I might add, yeah. I think the implication is the second notice effectively is written water, yeah, and can be ignored.
Well, that was the argument made in the Court of Appeal, and the answer that we put was that properly...
But it doesn't matter. I mean, if it was written water, you've still got a valid October notice.
Well, the point taken against me on that is that it wasn't pleaded in that manner.
I mean, there's so many different ways of putting the same point.
Yes.
Yes.
I mean, you can amend now if you need to.
Yes, well, actually, I was not given the opportunity or suggestion that it should be amended in the Court of Appeal. I'm not sure where that's come from, but it's clear from the transcript that although there was a discussion about the basis on which the case was put, there was no suggestion that amendment was required or offered.
Before you go there, are you going to deal with the question of the terminology of the first notice?
But I was going to do it in the context of the notices themselves because, as I said, I don't, with respect, submit that it is an aid to construction of the clause because it came afterwards. But I do, with respect, because the point about the wording of the notices is taken against us, I do, with respect, come on to deal with exactly what they say and the differences between the first and the second, and also to look at the correspondence that took place before and afterwards, because that, in my respectful submission, is the answer to a number of the points that have been made.
Well, you say the critical date, I think your submission earlier was the critical date is the 9th of July 2013, but how then, I would be grateful for your assistance on how then do you deal with the terminology of the first notice referring back to the earlier date? But you'll come to that at some point.
Yes, I perhaps didn't make it clear earlier. The document refers, the clause 6.2 of the amended agreement refers specifically to the 9th of January 2012 as an anchor point rather than as a trigger date. The end point is not specified. It's 18 months thereafter, and there may be a debate, no doubt in this case there would have been debate, as to whether that ran from the 9th of January 2012, which is what we said, or whether it ran from some other time. And so the wording of the notice certainly links to the date that's specified in the clause and doesn't go on to repeat the remaining words in the clause.
Well, can you rely upon the later date if your notice refers only to the earlier date?
Yes, well, we say we can, and that the wording of the notice is sufficiently clear to make it apparent that the option is being enforced. It's the option under section 6.2.
And you say that's all that matters?
Yes, yes. Well, I'll go further and develop it as we look at the correspondence, but it's clear that the appellants knew that enforcement in accordance with the option, that clause was taking place. Perhaps it's worthwhile looking now at the correspondence leading up to that material. I say this against the background of two things for my lords, my ladies' notes. The Court of Appeal ruling, paragraph 25, deals with the issue of whether the notice was issued in a reasonable time, even assuming that the date ran from the 9th of January 2012. That's paragraph 25.
Yeah.
Court of Appeal says at page 41 of the bundle, VDM would have been entitled to a finding that the 14 October notice had been received by the appellants within a reasonable period of time. I say this because it is clear from the evidence that throughout the period from 9 January 2012 down to 9 July 2013, the appellants intended to construct a residence on the property, and VDM was prepared to allow the appellants considerable latitude as to the timing of such construction, whilst at the same time making the odd inquiry as to when such construction would take place. Now, my respectful submission, the reference to odd inquiry is not particularly helpful to me, but as we'll come on to look at now, there was some more to it than that. If I could ask the board please to pick up bundle 3 and start at page 713. one sees that a letter is sent from Vista Del Mar to the appellants on the 20th of June 2011.
Which page again?
We have 713 at the bottom.
Thank you.
I'm in bundle 3. And this is a letter to the appellants noting that the Architectural Committee had granted a building commencement date of January 2012, noting in the penultimate paragraph on that page that architectural plans take considerable time, as well as submitting plans to the Planning Department, looking forward to reviewing the plans and inviting a call. So that is in good time in June 2011 before the first trigger date of January 2012. If we then move through to page 716, it's difficult to read the date, but this is an email again from Vista Del Mar to the appellants, particularly their architect, Mr. Doak, dated the 1st of August 2011, referring to a meeting, referring to an earlier letter and preliminary sketches, noting that this provides an outline of the proposed residence which did not raise any red flags, looking forward for further material, and saying again, we've noted that your clients have indicated a construction start date in January 2012. We would be grateful at the time of making your submission if you could kindly confirm that you are still on track for this date. And then what we have at the next page, 717, is a letter coming back from Mr. Doak, dated the 18th of November 2011. And in the third paragraph, there is confirmation that planning permission has been applied for. And in the fourth paragraph, the penultimate paragraph, with reference to the earlier email, that's the one we just looked at, construction is scheduled to commence by or before Easter 2012, subject to upcoming holiday periods, the building permitting process, and finalising a construction contract with a builder. So there we have a couple of months before the January 12 so-called deadline, an indication from the appellants that in fact it's going to be Easter 2012 before commencement is undertaken. The next email is 2 pages on page 719. That is dated the 27th of February 2012, again from Vista Del Mar to the appellant, Ms. Francis. Can you please, this is the third line, the third sentence, can you please update us as to your construction start date, please? And we see over the page then at 720, at the bottom of the page, it's difficult, is an email dated the 27th of February from Ms. Francis to Mr. Joseph. Last sentence, we are waiting on bids which we hope will arrive soon. And the response is at the top of the page, the 28th of February. Third paragraph, thank you for letting us know that your house is in the bidding process, which means that construction could commence within the next 8 weeks. Please don't forget to supply us with a copy of with a sample of your rooftop. Now, it's not suggested that as at the 28th of February 2012, perhaps 6 weeks after the January 2012 date, Vista Del Mar was under the impression that construction would be commencing within the next 8 weeks, which one assumes would give time to complete construction by July 2013. Now, what happens next has the effect of delaying that timetable significantly. On page 721, we see an email being written by Mr. Doak to the appellants. This, of course, was not seen by Vista Del Mar at the time. This comes out of the disclosure process. It refers to UKPC, the project name for the house, small town in Jamaica. Ian Fleming has his house there, GoldenEye, as did Noel Coward, Firefly. So that's the name that we see going through the correspondence from the architect. And what that says, I won't read it out in detail, is that unknown to Vista Del Mar, significant changes to the plans which had already been submitted to the planning authority were requested, leading to changes in scope. One can see the reduction of the width of the house, the depth of the verandas, the size of the garage, and various omissions listed in bullet points. So in March 2012, contrary to the understanding that construction could commence, major changes were undertaken. And one sees in the correspondence which follows further significant amendments being made to the plans on page 722 and 723. And that leads at page 724 to a follow-up eventually from the respondent, noting in the last paragraph that no building plans or other communications had been received stating the intention to start building the house. Please inform us of your latest plans, schedule, or explanations regarding this issue, etc. One sees from the bundle, and just to make it clear, this is a reproduced bundle that does not include all of the materials before either the Grand Court or the Court of Appeal. You see some note being made by the Grand Court judge in her transcript that a lot of material had been put in, 800 pages of exhibits, and that was also before the Court of Appeal but has been stripped out. So we don't have the full bundle that was in front of the judge, but we can see through at page 739.
I mean, this 724 suggests there had been a previous letter dated June the 20th.
Yes, the only one that we've been able to find is
I see 2011. So that's
yeah,
yes, I see.
2011.
Yeah, okay, thank you.
This one, although it's copied to Mr. Freytag and Mr. Joseph, it's actually from the Residents' Association, isn't it, rather than the current respondents.
Well, at the time, that company, Vista Sur Maintenance, is owned by Vista Del Mar, because until Vista Del Mar sells all of the parcels of land, it retains control of, it's called the maintenance company, we usually call it a strata committee or an executive committee that is run through. So it's, Miss Rendon works for Vista Del Mar.
Right.
See that in the name. And then at 739, we see another letter, again by the same parties, noting an earlier conversation on the 4th of December 2012, where you're in the process of interviewing contractors. We're wondering whether you have made your selection and have any idea when construction will commence. Now, one can see also in the first paragraph of that letter a reference to the fact that the development is filling up. Second sentence, with only a few unsold lots remaining and a healthy sales activity, we're expecting even more growth this year, more growth in the community, one assumes that means. So we get to the point in March 2013 that the fact that there are fewer and fewer houses left to be developed is starting to drive Vista Del Mar towards more detailed inquiries as to what is happening with parcel 290. And at this stage, March 2013, we're getting close to what I call the long stop date of July.
The prospect of getting it built by July is looking increasingly remote.
Yes, and that's an interesting point with respect, my Lord, because one of the things that's noted in the Court of Appeal transcript is, well, what happens if you do get permission to commence at some point after January 2012, and it's clear that you may not be finished in time for July. The way that Sir John Martin described it was, well, you would be at some risk if that was the position you were put in. But with respect, what I would say in response to that, had the question been put to me, is if it had got to the point where construction was commenced and it was clear that it was going to run out past the long stop date, another long stop date and another extension would have been advisable. And we can see that that's what indeed was happening on some of the other properties where Vista Del Mar, contrary to what my learned friend has said this morning, was pushing owners, purchasers, to start building. And once it felt that construction was underway, long stop dates were then imposed. So we submit that that's what would have happened here if construction had commenced. Now, I pause at this point because that's the correspondence that took place prior to the 9th of July 2013.
In fact, there was no building done before 9th of July at all, nothing.
And when the Court of Appeal reaches its conclusion that there had been no unreasonable delay between the 9th of January 2012 and the long stop date of July 2013, it's done partly on these documents that we've looked at, and the Court of Appeal was taken to all of these documents on the appeal. I should say also that the witnesses covered what was happening during that date in brief detail in their written evidence. That's done by way of witness statement in the Cayman Islands, and the references for the appellants were Ms. Francis's witness statement. It's at R2, page 308, paragraph 12 and 13. Perhaps I should just ask my lords, my ladies, to turn that up. R2, page 308, the witness statement of Ms. Francis, paragraph 12. In that paragraph, she talks about the period between May 2011 and April 2013. She explains that she is regularly off island attending to her terminally ill mother, who was hospitalised in Houston and who sadly passed away in April 2013. She reports that she was heavily involved in winding up the affairs that arose from that, and that there was not much progress on construction. But thereafter, she began to take steps again. That was her explanation as to what was happening at the critical time of January 2012 to July 2013. In fact, there is a lot of information in the bundle of the type we looked at showing that progress was being made to change the design plans which reset the planning approvals and building approvals needed, but Vista Del Mar was not being told about that at all stages. But then she goes on in paragraph 13 to say, we continued to provide regular updates on our progress to Vista Del Mar by both telephone and in writing, and provised revised construction schedules. We've seen some of those we haven't seen all of them because of the bundle. But note the last sentence, the responses from VDM, in particular Mr. Joseph, were always cordial and understanding. So one sees there an explanation for why time was running that we respectfully submit is not unreasonable, having regard to this difficult position that the appellants were in and having regard to the correspondence that has been looked at. That was firmly in the mind, we say, of the Grand Court Judge and the Court of Appeal. Mr. Joseph's witness statement is at the same bundle, pages 292 to 293. Same bundle, 292 to 293, paragraphs 23 through to 26. He says that he had understood that as planning permission had been applied for, construction was likely to commence as soon as the planning permission was forthcoming. Some chasers had been sent. Ms. Francis advised that they were waiting on bids which they hoped would arrive soon, and he said he thought that was happening within the next 8 weeks. We've looked at that correspondence. And then it went quiet in paragraph 24. There was a phone call. He was told that progress was being made. And on 25th, we see another follow, paragraph 25, the 4th of March, we see another communication in which it is suggested that a decision had more or less been made to select the contractor. There was a reference to a follow-up on the 31st of July and the 4th of August. And Mr. Joseph goes on to say in paragraph 27, however, that by September 2013, more than 18 months had elapsed, and it began to appear to him that contrary to all assertions, the defendants had no real intention or ability to commence construction. So that's the evidence we say which demonstrates that even if my interpretation of clause 6.2 is not accepted, and the first trigger date is the key trigger date, what happened between that date and the issuance of the first notice was understandable, and therefore the timing was reasonable in all respects.
Can I just mention, if you're pausing there, can I just mention something? We gave a decision in July of this year in a case from Trinidad called Singh and Rainbow Court Townhouses Limited, which was about enforcement of covenants in a scheme. And one of the points which came up was the extent to which the owner had waived enforcement against some of the other people, and there was certain evidence of that. I don't think it really affects our facts, and in the end we sent it back for other reasons, but it does simply may be relevant in the sense that it puts the issue not in terms of clean hands, but rather whether the owner led the relevant person to think that the covenants weren't being enforced or were no longer enforceable. So it's a slightly different way of putting it, but I just thought I ought to mention it just so that in case it's of any relevance. But I don't think it really affects the way you look at it on the facts of this case.
I'm very grateful, my Lord. You will have seen, I think my lady mentioned it, the email from Mr. Clark to his architect, where he says we need to get moving on this because VDM are talking about exercise, and we've made a lot of progress, but they wish to preserve their rights. So it's a part of the case that was presented in the Grand Court that, as the board can see from the communications, Vista Del Mar was being told that construction was imminent. It wasn't being told that UKPC was being amended, which would lead to a very long delay. in that construction.
I was only mentioning it simply so that you're aware of it, and we referred to a case called Chatsworth Estates and Fuel, Mr. Justice Farwer. But
It was a slightly different case on its facts.
Yes.
It was one where in that case, the person who had bought the lot had actually built on it, but had built not in accordance with approved plans. And her defence, effectively, to being asked to pull down what she'd built, was that she had acted in reliance on a waiver by the management company because they, according to her, had permitted other people to build unapproved constructions.
Well, that's very helpful. I will take a look at it during the break, if I can. The point I would just make in response to that was that the Vista Del Mar Architectural Committee had the initial obligation to approve all of the plans, and that's why we see asking for a copy of the roof tile, so that there's an aesthetic presence to all of the houses in that particular development. So one could see it would have been difficult for that scenario to have arisen in our case.
yeah, okay. Well, the reference is 2018 UKPC 19, but as I say, I don't think it's really going to affect either of our arguments, but for completeness, I thought I should mention it.
Now, I wonder if we've reached a natural break.
Yes, my lord.
Very well, we'll adjourn.